Hello, this is State Representative Arthur O'Neill reporting to you from the floor of the House of Representatives in Hartford. It's March 12th. Today we voted on the nomination of Andrew McDonald to become Chief Justice of the Connecticut State Supreme Court. I voted no on his nomination. I did so because I believe that he violated a promise that he made to me that he would be very careful about recusing himself in any case that really involved Malloy or the Malloy administration's policies. He served as Governor Malloy's attorney in the first 2 years of the Malloy administration, and as such he was deeply involved in many of the policies and much of the decision-making of the Malloy administration. He understood that, or at least he said he did, during a hearing on his original nomination to go on to the State Supreme Court in 2013. We went over this very carefully, and he said he agreed that he would recuse himself in the cases where the Malloy administration or its policies were actually involved. He didn't keep his word. 5 years have elapsed, and he's voted on any number of cases where I believe he should have recused himself. The most notable case, and one of the earliest ones, was the Santiago case. That's the case in which the death penalty in Connecticut was overturned. A piece of legislation was passed during the Malloy administration while Mr. McDonald was Malloy's attorney. At that time, it was assured to many people that the legislation would repeal the death penalty prospectively, but would leave in place all of the death penalties that had been imposed earlier, in particular the death penalties in the Cheshire murders of Komisarjevsky and Hayes. When Mr. McDonald went on the court, he voted to overturn the death penalty, and it was retroactive, which meant that Hayes, Komisarjevsky, and the other people on death row would have their sentences converted into life sentences instead of death sentences. But my real problem with Mr. McDonald is not that he voted for or against the death penalty, whichever way he went. My real problem is that he should have recused himself. He should have disqualified himself, because under Connecticut law, he could easily have done that, and a different judge could have been brought in to take his place and hear the case. He was not really needed for that particular case. He could have recused himself, and he chose not to. I believe that he did not keep his promise with me, and I don't believe that he can be trusted to make the correct decision on recusal in future cases as well. Unfortunately, his nomination passed the House of Representatives by one vote, 74 to 75. And unfortunately, it is now going to the State Senate. It is my hope that they will turn his nomination down, and we will get a new nominee to consider. Thank you for listening.